I'm Leo Raznovich, barrister in England and Wales, based in the Cayman Islands, where my current works focus on LGBT rights, in particular the laws that criminalize LGBTI people and the lack of equality laws in British Caribbean territories. In this brief presentation, I will discuss the publication in March this year of the final report consolidating the results of an investigation carried out between the years 2017 and 2019 in Latin America and the Caribbean, looking at the human rights to respect for sexual orientation and gender identity in the region. I shall first provide a brief background of the research, then share two conclusions relevant to the Caribbean region for which I was responsible, and end with a reflection. About the background, I was responsible for the Caribbean chapter of this research, and Raúl Zaffaroni, Justice of the Inter-American Court of Human Rights and Emeritus Professor at the University of Buenos Aires, was responsible for the Latin American chapter and for the drafting of the report. 5 years ago, I invited Raúl Zaffaroni to the Cayman Islands for a conference about LGBTI individuals and equality in the Caribbean. The conference, entitled Queer Paradigms, the first in the region on the subject, left both of us with a very gloomy panorama for LGBTI people in the region. The conference was a great success in that it was the catalyst for equal rights in the Cayman Islands, something that we finally achieved last year, managing to shift British policy in relation to its colony by compelling the UK government to legislate for equal rights for LGBTI people in the Cayman Islands in order to comply with its international obligations under the European Convention on Human Rights. But more importantly, that conference in the Cayman Islands 5 years ago led to this research. I would like to state for the record that it has been an honor and a privilege to work with Professor Zaffaroni in this very seminal and transcendent research, which even drew the attention of Pope Francis, who invited us to the Vatican to discuss the preliminary conclusion of this research in April 2019. This research has been possible for the joint effort of many institutions: the Inter-American Institute of Human Rights, the ILANUD, and the International Bar Association, amongst many of them. I would like to emphasize how incredibly important it is that organizations such as the International Bar Association, with its immense amount of knowledge and resources, gets behind projects such as this and help to catalyze important legal and social changes on matters which have the potential to help bringing about positive changes for many millions of people throughout the whole American continent. I would like to share two conclusions of the research are responsible for the Caribbean chapter. The first conclusion is about a thought that Michael Kirby shared with us. Michael Kirby is a former judge of the High Court of Australia. And during the debate of the interim report of this research, he shared with us that authorities of some of these 10 countries still laugh at the recommendation of the Inter-American Commission of Human Rights regarding repealing these laws. He explained that when he raised this in Jamaica, the Attorney General, and I quote, would divert the conversation towards the Australian cricket team rather than to talk about repealing these criminal laws. It is no longer acceptable that the Inter-American Commission of Human Rights continues in the hope that these countries will implement its recommendations. Furthermore, it is unethical and may be construed as a breach of human rights by the Commission itself to expect that a person should risk his or her life to bring a claim internally so that by the end of 2030 or 35 it reaches the contentious jurisdiction of the Inter-American Court of Human Rights. Jason Jones of Trinidad and Tobago and Maurice Tomlinson of Jamaica shared with us during the debate of the interim report of this research that when they dared to do so, they were forced to seek asylum in Canada to save their lives. One of the conclusions, therefore, held that the Inter-American Commission of Human Rights has the power to seek an advisory opinion from the Inter-American Court of Human Rights on the validity of these laws under the Convention and other human rights instruments. And it is hoped that with this report in hand, the Commission will act without further delay and obtain that opinion. Conclusion 2. The British Crown and its Privy Council, unlike the Caribbean Court of Justice, has become an obstacle on the road to advance the rights of LGBTI people in the region for countries where they still serve as the final court of appeal. In fact, rather disturbingly, the British Crown and its Privy Council have remained the guardian of all colonial laws by imposing their validity over and above the Constitution of Independent Nations. In 1984, the Bahamas Parliament abolished colonial laws that provide for corporal punishment, but restored all of them in 1991 again. In 2002, the British Privy Council, in the case Pinder versus the Queen, accepted that flogging is an inhuman and degrading punishment contrary to the Bahamas Constitution, but held that such a barbaric punishment was immune from judicial scrutiny to the extent that it had been originally introduced by colonial laws. The principle of constitutional interpretation that the Privy Council set out in this case is derived from what is referred to as special saving clause that apply to a particular law or type of law, in this case a clause that preserved colonial punishment. This principle is simple and controversial and can be restated as follows. Colonial laws never die. They can go into a coma, but national parliaments can always resuscitate barbaric colonial punishment, notwithstanding that it has been repealed in the past. It is prohibited by the Bill of Rights of the Constitution, and it is universally held inhumane, cruel, and degrading. Following this principle, it will not shock the audience to hear that the following year, the Privy Council confirmed in the case Boyce versus Barbados in 2003 that notwithstanding any colonial laws may be, and I quote, inhuman and degrading, the judiciary of independent states cannot touch them in the instance case by the application of general saving clauses that apply to any laws passed at any time during the colonial era and in force at the time of independence. In a more recent case from Trinidad and Tobago, where the Court of Appeal of Trinidad and Tobago had held that equality before the law, which is secured by the Constitution of Trinidad and Tobago, requires that sexual orientation be a protected characteristic under the Constitution, the Privy Council reversed this decision. Surratt versus Trinidad and Tobago, 2007. Inexplicably throwing out the window the purposive and generous construction of fundamental rights that the same Privy Council had used since 1929 after Edwards versus Canada, case in which they declare that women are persons. There is currently 2 cases pending before the Privy Council about same-sex marriage, coming from Bermuda and the Cayman Islands. The case law precedent referred to above does not give much hope, but to expect that the Privy Council will conclude that equality before the law does not include LGBTI people, taking in effect the laws of these 2 British territories back to 1896, when the United States Court held in Plessy versus Ferguson that equality before the law did not protect people on grounds of race, setting out the principle of racial segregation by bringing about the doctrine of separate but equal. If this outcome were to be confirmed, the British Crown and its Privy Council will not only be clearly the guardian of colonialism in the Caribbean region after Pinder and Boyce, but assisting and colluding with the homophobic politicians of the region to maintain the structure of criminalization and segregation of LGBTI people against decisions of the European Court of Human Rights and the Inter-American Court of Human Rights. In fact, if Boyce were not reversed in line with the decision of the Caribbean Court of Justice of 2018 in McEwan versus Barbados, the colonial laws against sexual intimacy between 2 consenting adults of the same sex passed by Henry VIII in 1533 will have to be declared valid by the Privy Council, regardless of how abhorrent or degrading are considered today. Let's not forget what Lord Hoffman said in the case of Boyce versus Barbados. Notwithstanding any colonial laws may be, and I quote, inhuman and degrading, the judiciary of independent state cannot touch them. This immunity, he stated, and I quote, for the avoidance of doubt is absolute, end of quote. The second conclusion, therefore, held in the report that an inquiry of the possible responsibility of the British Crown and the international law for the decision in Pinder, Boyce, and Surratt would be desirable and would be opposite if the predicted outcomes of the cases on equal rights and criminalization are eventually confirmed. It is therefore hoped that the United Nations expert on sexual orientation and gender identity would take the lead on these rather disturbing harms being caused by the British Crown and its judiciary to the people of the Caribbean nations. My reflection is as follows. The violation of the rule of law is sadly not exclusively witnessed in the executive and the legislature. It may be witnessed in decisions of the judiciary as well, particularly when judges are prepared to say in the third millennium of the judges of the British Privy Council implied in 2003 that the validity of laws passed by Henry VIII 500 years ago, regardless of how cruel and degrading they are, cannot be questioned by the judiciary of independent sovereign nations. Today, or as they held in 2007, the constitutional provision for equality before the law do not include protection on grounds of sexual orientation and gender identity. This research evidence that 10 countries in the English-speaking Caribbean still make it a criminal offense sexual intimacy between two consenting adults of the same sex, laws the origins of which can be traced all the way back to Henry VIII. This is not a problem in one or two countries with an isolated human rights issue. This issue is endemic in the Caribbean in 10 countries that represents almost 1/3 of the members of the Organization of American States. In this country, their executives and legislatures are making a concerted effort to retain these laws on their statute book with the effect of terrorizing LGBTI people. Moreover, they're doing this in some instances with the assistance of the judiciary, the British Crown, and its Privy Council. Regardless of what the British judges in the third millennium believe about sexual orientation and gender identity, boys, being the Montserrat, are wrong as a matter of law, in the same way that racial segregation was wrong in 1896, and in the same way that holding that women, not being a person, was wrong before 1929. But more importantly, they are wrong as a matter of principle in any decent society. Thank you.